Ladies and gentlemen, I'm John Parker with Gardner Parker Insurance here on the corner of Taylor and Bell Streets in Zanesville. And from time to time, I put videos on YouTube regarding insurance issues or any other issue that I think is pertinent. And today I have with me Assistant Prosecutor from Muskingum County, John Lytle, and we are going to discuss issue 1, which is something that we are all going to be voting on here at this election, and it is very important. And bear in mind that it is an amendment to the Ohio Constitution. So thank you, John, for coming.
Thanks for having me.
John, issue 1, I'm told, relaxes a lot of penalties, and what are considered felonies now will be considered misdemeanors and so on. Is that correct?
It's partially correct.
Okay.
One of the things to understand is when there's a statute, or in this case an amendment, what matters is the actual language of that amendment, not what people say or what they explain that they want it to do. So there's two ways that you can read the actual text of this amendment, and there's two places where it addresses what it's doing with the crime of obtaining, possessing, or using narcotics. The first section of the amendment says that it cannot be a felony for any possession of drugs or any crime that would constitute possession of drugs now. And then in a second section of the amendment, it talks about how the amendment does not apply to convictions for felonies of the third, second, or first degree level of possession offenses now. That seems really complicated, but the amendment says up front, you cannot make it a crime higher than a misdemeanor for possessing drugs.
No matter what the drug is.
And no matter how much it is.
And no matter how much it is.
Then it goes through some other things, and it says people who are in prison right now for having committed a possession of drug offense can petition the court to come back. So they've been convicted, and now they're currently in prison. They can petition the court to come back and have their crime reduced to a misdemeanor. And then below that, it talks about this does not apply to convictions for felony 3, felony 2, or felony 1 level offenses. Well, here's the thing. The people who have drafted this think that that little phrase applies to everything that they're talking about, but it doesn't. It says convictions. There will no longer be any convictions for F1, F2, or F3 level possession offenses, because you can't make those anything higher than a misdemeanor under the statute. So I know that seems really complicated in the way that the words play, but that is what this amendment reads. And there's what's called the rule of lenity in statutory construction. It basically says if there's confusion between two interpretations of a law or a constitutional amendment, then the court goes with whatever benefits the accused and interprets it against the state. So if you have two different ways of interpreting it, then the thing that benefits the person who's charged with the crime is the way that the law is interpreted.
So for Joe and Susie on the street here walking around, tax-paying citizens, what does this actually mean for them?
Right. Well, let's talk about this and separate some of the issues in issue 1. Issue 1 markets itself as something that just has to do with drug cases, but it doesn't. It affects all crimes. So for instance, probation. One of the things that I think issue 1 is most troubling is when someone is placed on probation, they cannot be revoked from that probation and serve a punishment unless they're convicted of a new crime, no matter what. So let me give you an example. I steal $149,000 from you. Significant, right?
Yeah.
Under Ohio law, that's a felony of the 4th degree. I don't have any prior felony offenses or convictions, so I'm not eligible to be sent to prison for stealing that $149,000 from you. I have to be put on probation. Now that I'm on probation, someone can say, well, I'd like you to do treatment and go to a theft class and maybe pay you back your $149,000. Under issue 1, I don't have to pay you a dime. The judge can say, pay him $149,000. I can have $149,000 in my hand. I can wave it at you. But I'm just going to say no. And it's not a crime for me to say no. And so I can't have my probation violated, and I can't go to prison ever.
So there's no recourse for the person that has lost $149,000.
Well, what you do is you have to sue me civilly and hope that you're going to get that. But if I don't go to treatment, cannot be punished. If I don't do anything I'm told, if I won't tell my probation officer where I live, if I'm never where I'm supposed to be, if I violate my curfew, if I call you and harass you on a daily basis, that could rise to a level of a crime. But let's say I do it and I'm just harassing you for the fact that you can't do anything to me. Probation can't be violated. So that happens, and that happens for drug offenses and for every other offense. So that's just one example. Let's talk about the drug offenses. Let's take it in what they want the bill to do as opposed to what I think the bill actually will do. If you take people who can possess date rape drugs, enough fentanyl to kill 10,000 people, and you say, okay, just carry this. You can have it out there. There's not gonna be any punishment. We all feel the outcomes of that lenience because we can't get treatment for these addicts because the addicts don't want treatment. Like, I don't know if there's sometimes people will get to a point and say, I want to seek out treatment. And that's where we're trying to get them, because that choice, I want treatment, is the only thing that matters in terms of getting success for an addict. But most of the time, going down the road, smoking my dope, injecting it, they're not out seeking treatment. We're trying to get them to want to get treatment in the criminal justice system. People have their families pressuring them to get treatment. They have their friends who pressure them to get treatment. They have their own self-interest. I mean, half the drugs now are laced with fentanyl. At any point, you could use any drug and end up with a hot shot and you overdose. Those are not influencing them to seek that treatment. And that's how you end up down in the criminal justice system, where we're trying our way to try and get people to seek treatment. It's not like we're just warehousing everybody. We give them probation and order them to go to treatment. If they don't go to treatment, just saying, well, then in that case, we're done with you is not effective. So we have drug courts, we have other things trying to influence people, and we have the consequence of you're going to get locked up if you don't do this. And sometimes the threat of locking people up is the thing that gets them to say, okay, I'm going to engage with treatment. But for other people, they don't care. And sometimes it's actually being locked up, which brings them to their bottom, to the point where they say, I don't want to do this anymore. And then that is the thing that helps move them on in their life. And it doesn't give anybody joy to lock somebody up in a cage. The effort, particularly with addicts, is 1, stop you from harming other people, and 2, stop you from harming yourself. And that's gone for all these addicts with issue 1. It's just not there. There's no drug court because you can't have a consequence.
Why in the name of time would anybody draft a legislation like this and get it on the ballot?
I think that people have a unrealistic understanding of how it is that treatment, I guess, occurs. I don't think that the people drafting this are not bad people. I don't think that they're deliberately attempting to sabotage our entire state, but that's what they're doing. I can even go into the nuts and bolts and kind of explain why. Based on the way the law is, there won't be any more drug prosecution for those people. So when you say it's a misdemeanor, well, yeah, it's a misdemeanor, but those cases will never proceed. We have to bring someone to trial within 90 days on a misdemeanor. It takes us 270 days to get a drug test back from the state. So you just can't.
There you go.
It's just done. Yeah. So there's no treatment for these people. And that's the thing. Saying, okay, we're going to divert all this money to treatment. 1, there's not going to be any savings of money. And 2, it's why would a person who doesn't want treatment pursue it when there's no alternative consequence. They
Right.
just won't.
And you know, John, I've served on grand jury several times, and almost all the crimes that are thrown in front of the grand jury, almost so many of them come back to drugs, robbing somebody or breaking and entering, and on and on and on. It comes back to drugs.
Absolutely.
I'm sure you know that. I mean, but anyway, well,
It's 85 to 90%.
yeah.
Yeah.
There's
some domestic violence that's not substance related. There's some sexual assaults that are not substance related, and there's crimes of opportunity. Somebody embezzles from you or something like that. But 85 or 90% of everything that we deal with has to do with drugs or the loose cash related to the drug trade.
Yeah. And I mean, I've seen people in there in front of the grand jury, and you can look at these people and know that they could be productive citizens. And these drugs have just got a hold of them, and it's not going to let go. So it's sad. It's sad. But anyway, obviously, we are both drastically opposed to issue 1. We think it's very, very detrimental to the citizens of the state of Ohio. So, along with our law enforcement out here that's trying to keep us safe every day, John is a part of that too, like all the prosecutors and the judges, and they are adamantly opposed to issue 1. So you want to make sure you go to the ballot box and say no. So thank you for listening. And if you have anything you want to see me discuss on here, my phone number is 740-452-2656. Give me a call and we'll sure talk about it. Thank you.